25CR03118.
Do we have a brief recess, Your Honor? I've been here observing, and I'd like to step out to the boys' room.
Sure. Come right back in. I'm going to stay here.
Good afternoon, Your Honor. And Your Honor, my colleague here is just going to set up a smart board for us. We might have some video to play. So.
Sure.
Yeah, just because we just up there is fine, as long as the judge and the witness can see it, we'll be fine.
That's fine right there.
That would be, yeah, anywhere along there is fine. As long as it's not going to roll down the ramp.
And just as soon as it be at a slope, so yeah, like that, so that if the defendant wishes to see it, stay in his seat.
But it's okay.
Thank you.
Yeah, and so we have a couple of motions, I think, here. There is a hearing on a motion to revoke release. Is that right?
Yes, Your Honor, I think today's set for the motion to revoke release.
There's also a motion for jury view of premises. Is that not set on the docket?
I think the only thing on today is the motion to revoke release.
Okay, so let's deal with the motion to revoke release.
Thank you, Your Honor.
It's a state's motion, so your burden.
Appreciate that, Your Honor. And Your Honor, Kyle Fleming on behalf of the state here on a motion to revoke release. Just as way of introduction for the court, this is alleged as a menacing, a reckless endangering. The parties here, the two individuals, Mr. Thompson, the defendant, Mr. Reed, have neighboring properties. They had a shared drive, or they have one, the ownership of which is somewhat in dispute. Mr. Thompson believes that it's his exclusive right to use that shared drive. Mr. Reed disagrees. There's some civil litigation around that issue. But this menacing case was arraigned back in March of this year. Mr. Thompson signed a release agreement March 3rd, 2025. I'd ask the court to take judicial notice of that. It's in the file. It indicates I will have no direct or indirect contact with the alleged victim, Mr. Robert Reed. Mr. Robert Reed sitting here behind me. And since that time, Mr. Thompson has had direct contact with Mr. Reed. He yells things at him as they're driving by each other on the shared drive. And the one witness I have today is Mr. Reed. So the state would call Mr. Reed to the stand.
And this is on a motion, when,
State's motion to revoke release, Your Honor.
and that was filed, is it August 7th?
Let me pull it up. That sounds about right. I'm just going to make sure. And the state's motion to revoke release was filed on August 1st, Your Honor. August 1st. Oh, excuse me. The original one was denied because of a clerical error. Yes, it was refiled then on August. No, it's August 1st, Your Honor. So August 1st motion. And then the court issued an order to show cause on August 8th.
Okay, I see. That the actual order was, okay, yes, go ahead. And so your first witness?
Yes, Your Honor. So the state would call Robert Kim Reed. Mr. Reed.
So could you please step forward to the witness stand? Raise your right hand. You do solemnly swear that the testimony you shall give in this now pending matter be the truth, the whole truth, and nothing but the truth?
I do.
Please state your first and last name and spell your last name for the record.
Robert Reed, R-E-E-D.
Good afternoon, Mr. Reed.
Hello.
Mr. Reed, can I ask where you live, sir?
Let's have him name himself.
Oh, my apologies. Mr. Reed, can you state your full name and spell your last name, please?
It's Robert Kim Reed, and it's R-E-E-D.
Okay. So, Mr. Reed, can I ask where you live, sir?
I live at 50900 Maston Road in Lapine.
Okay. And do you recognize Mr. Thompson to my right?
I do.
Okay. Is Mr. Thompson your neighbor?
He is, yes.
Okay. So, does he have a piece of property that adjoins yours?
Correct, directly to the south of me.
Okay. And I understand there's a shared driveway that runs from Mr. Thompson's property over your property to the road. Is that right?
Correct. There is an easement that allows Mr. Thompson to access his property.
Okay. And so I don't need to get into a great deal about the easement itself. I just understand that the two of you you both use this driveway, for lack of a better term.
That's how we get to and home, or back and forth from our homes.
Okay. So to get to your house, you use that easement?
I don't use the easement. Well, I drive on the easement, but I own the property.
You
yes.
use the driveway?
Correct, yes.
And Mr. Thompson, to get to his house, he uses this driveway?
That's correct, yes.
Okay. So I understand back, we had a prior court hearing, and after that hearing, you ended up coming up to myself as well as a deputy a DA investigator to provide us some videos of Mr. Thompson having contact with you. Is that right?
That's correct, yes.
So I'm going to play a couple of videos, and you tell me if they're accurate. Permission to approach, Your Honor?
Sure.
Excuse me, Your Honor, if I may object, I'll raise this objection. This video was taken on my private easement to an area where I have a right to privacy. This is not admissible as evidence in any court proceeding.
So let's, let me ask a question. You can have a seat, sir. Go ahead. There is a piece of property that has an easement on it. That easement is as I understand easement, is the easement that is allows an access by somebody across someone else's property. Who owns the land on which that easement sits?
I do. My property is 26 acres, and the easement goes along the east side of my property for a quarter of a mile. It's 30 feet wide,
And you own the property.
and I own the property.
What's your point, sir?
The point is that I and my wife here own the easement. It's an exclusive easement by deed in 1971 between my aunt and uncle and my parents. It's been in my family the whole time. We're the sole holder of this easement. There's nothing on any record that grants the subservient property to which Mr. Reed has questionable ownership for the last few years to all of a sudden come in and take over this easement. He has no legal right to be on this easement at all. That's easement law, that's constitution. You can't come along and just take over somebody's easement when it's not necessary. His property has its original access and a road that doesn't involve the easement whatsoever. Easement law, Oregon easement law does not support that in any way, shape, or form, and there's no case history to support that. And this easement was created by deed on October 5th, 1971. We are the only holder of this easement. Mr. Reed, by his deed that's been altered, owns a piece of property that is subject to our easement. There's nothing grants him any right to it. And it's not just, it's an easement for roadway purposes. It's all spelled out on the deeds. And that does not mean simply driving back and forth. All roadway purposes, utilities, privacy, everything to do with the roadway that is part of our property. The deed says an easement, together with an easement 30 feet wide across this distance.
Your objection is overruled.
Okay. At this point, Your Honor, I need to, I've been down this road quite a few times, as you might see.
Sir, your objection is overruled.
Okay, well, I'm here by special appearance, and I'm objecting to this proceeding for two reasons. One, we probably should ask for a continuance, because it's my understanding that when a judge is assigned to another court, or a senior judge is assigned, there must be a Supreme Court order stating.
There is, in fact.
Well, I haven't seen that docketed or anything. Can we produce that?
With that request, it can be produced, but we're going to go ahead with the hearing.
Okay, and so it should be in the docket. It's required. I haven't seen it. We've been through this before. I've never seen one. When I've asked for one, the judge has disappeared. So, okay.
It's not going to disappear.
May I approach, Your Honor?
Sure.
Thank you. So let me stop just so you can give us some context. Video you took.
That is correct, from my cell phone.
So, and I hear a motor running, you in a vehicle?
I'm on a four-wheeler.
Okay, so you're on a four-wheeler, you're holding your cell phone, you have it on the...
I'm holding my phone.
So you're holding it up?
Correct.
Okay, so Mr. Thompson driving down here can see you holding up your cell phone?
Absolutely.
Okay, so, and we're talking about an easement or driveway, we use a couple different terms. Is this what we're talking about, this kind of roadway we see?
That is correct, yes.
Okay, so this gravel road, and is this a gate up here?
That is the entrance to the main arterial there, Maston Road,
Okay, so Maston Road out here, and your property kind of behind?
is directly behind me here.
Behind you, okay.
And then Mr. Thompson's property is even further behind me.
Okay, and to you, does this appear to be a true and accurate copy of your cell phone video?
Absolutely, yes.
Okay, all right. Your Honor, state moves to admit Exhibit 1.
Hearing no objection, it's admitted.
Pardon? I didn't hear what he just said.
I'm moving to admit Exhibit 1 into evidence, sir.
Well, I object. Even the whole premise of this thing, you look at this video. I am sitting there on my deeded private exclusive easement. I'm not contacting anybody. I am sitting stationary. There is such a thing as first in time, first in right that goes back to preschoolers getting in line. I'm on my easement. I'm not contacting anybody. I am being contacted by Mr. Reed here and his father. This goes on all the time. They totally misinterpret this conditional release agreement and do nothing but stalk us day in and day out, all day, all the time. So I object.
I'm subject to I'm going to see what else is involved in this video. I don't know what else is involved.
So, was that Mr. Thompson in that vehicle?
It was, and his wife.
Okay. Was that Mr. Thompson we heard yell out trespassing at you?
It was.
Okay, so I'm going to play another video for us. Okay, so Mr. Reed again, is this you taking the video?
It is.
Okay, where are you right now?
I am actually now facing to the south. My house would be down there, you can see. And then Mr. Thompson's property is further on down there. And Maston Road is directly behind me and what we call the entrance gate.
And are you on your four-wheeler again?
I'm on my four-wheeler, and just for correction, I now realize that I was actually on a UTV last time, not my four-wheeler, but on a UTV.
Okay, so you got a couple different kind of ranch vehicles.
Correct, yes.
So here's a four-wheeler.
That's correct, yes.
You holding up your cell phone again?
Again, I am.
Okay, and this vehicle, who's in this vehicle?
That is Mr. Thompson, and I'm not certain whether his wife is with him or not.
Okay, and as far as you can tell, it's a true and accurate copy of the video that you
Yes,
provided? Okay.
it's accurate.
Play this real quick. So, you're in a four-wheeler, you're the driver.
I'm the driver, correct.
So, Mr. Thompson, presumably, from your perspective, you believe he knows it's you he's yelling at.
Oh, yes.
Okay. Your Honor, the state's going to move to admit Exhibits 1 and 2, both the cell phone.
In your objection, sir?
Yes, I object to all of this. It's taking place in my private curtilage to my home where I have an expectation of privacy, and it's nobody else's easement to use or to do anything with. All anybody else can do without my invitation is interfere with the use of my easement, which is part of the enjoyment, the quiet enjoyment to my property. It begins at the end of my easement where I access the public road.
So, can I ask a question of you? When did you come into ownership of the property?
In 2000 I believe November of 2020, or actually December of 2020.
And so this easement was pre-existing your ownership and you bought it subject to the,
Can I make a correction, or not correction, but, so my parents purchased the property in 1971, the same time that Mr. Thompson's parents bought their piece of property. So,
and so somebody got an easement on this piece of property.
correct. When the property was divided in 1971, it was divided into, I believe, 7 different lots. My parents became the owner of one, the Thompsons became owners of another, and others were sold along the way. The original owner of the property, the 26 acres that I now own, was retained by the original owner of the property, and he retained that property until after he passed. Then his wife put it for sale to my parents. My parents bought that property from them in 1988. And so my dad's 92 and my mother's 92 or 88, and they're still living right there on the property.
And then you gained possession.
Correction, they gifted me and my wife the 26 acres, and we built a new house on that piece of property.
Was the driveway constructed?
It was created with in 1971 by the original owner of the property, but he would just drive out through a field. I mean, he had 160 acres there, or more than that, somewhere in that area, and so he would just drive out through the field, and that's what they did. Then when my father became the owner in 1988, he opened up the easement that was created in 1971, and from that point on, the Thompsons would go through that created easement, 30-foot easement, and it's been in place since then.
And your father would use the driveway too, or the easement?
They ran cattle on that property, and so they would get in and out of there. As a matter of fact, my father was the one that constructed the fences, the gates, purchased all of the gates, did all of that stuff. Correct, yes.
Your and your dad's cattle running on that property continue?
Until the age kind of got in the way, and I believe they quit actually running cattle in about 2005 or 6, I believe, at that point in time, and then they just leased property for people to pasture their cattle, and my mother had horses, and so there would be horses on that property. Then when I became the owner of the property, I purchased, or I had steers on the property.
Your objections, what, sir? Not sure I understand what your objection is.
My objection to specifically what, Your Honor?
Well, you were objecting to the admission of property, that somehow you had,
Yeah, well,
in effect, a fee simple ownership of that property that nobody else could step foot on or use it for any other purpose.
exclusive easements have been ruled by the Supreme Court as being essentially the same as fee simple. And Mr. Reed here has no idea about his dates he talks about. When he talked about 71,
Sir,
I'll testify to these facts, and then you're going to find them to be very different to what Mr. Reed has testified.
okay, but at this point, I'm going to admit the exhibits. Is it Exhibit 1 and 2?
Yes, Your Honor.
So Exhibit 1 and 2 are received. I don't believe that easement as you describe it does not allow somebody else, that is the owner of the property here, underlying that easement, to be on the property, beyond that easement.
That was all established before October 5th, 1971, when the deed was recorded. That is a contract that took place then. It was recorded in Deschutes County. It was between my aunt and uncle and my parents, and that was the purpose of it. It was not, that easement was not required for any other piece of property. It isn't conceivably required for any other piece of property. And the only way it has been used in recent years, there was never a problem, by the way, until my parents both died in 2012, and I became the owner. My parents never lived there. The easement property, the Soviet property was never lived on by Mr. Reed's parents. That's a whole separate piece of property across the river. So it's, and by the way, this has yet to be litigated. So here we are trying to take advantage of the criminal system and make the state pay for litigating something that has yet to be litigated, because every judge here has declined to look at the property deed. The deed says it all, plain and simple. And the deed is the foundational document to all of this.
So Exhibit 1 and 2 are received.
So, Mr. Reed, we just saw those videos. So that both those videos, is that Mr. Thompson addressing you directly?
That is correct, yes.
Okay. And both those videos are taken near the end of July 2025?
Yes.
Okay. So,
Correct.
if you remember, do you remember around what dates you took the video?
I believe was most of it was in the middle, or the month of July, and I believe the first part was around the 15th, and the other one was around the 29th.
Okay. Are those the only instances of Mr. Thompson addressing you directly since that March date when the conditional release agreement came into force?
There are multiple cases where that's taken place. As a matter of fact, those two are two of the less egregious examples. Mr. Thompson has actually walked right up to me, right up in my face, and yelling at me to stay off of the property, screaming at me, cursing me.
When's the last time that he did that, if you remember?
The most recent one was the day before yesterday.
The day before yesterday. What happened? Why don't you describe what happened to us?
So I was, again, I've got a 26-acre piece of property, and I came from where our pump house is and a barn and things like that, and I came across a field to go across or onto the easement and back to my house. Mr. Thompson he came up on a bicycle, and so I just stopped to allow him to do whatever it was he was going to do, and he got out his phone, started taking pictures of me, and then basically telling me that I had no right to be there, things of that nature.
How many feet away from you did he get?
I'd say probably 40 to 50 feet, because I stayed back.
Okay. And he's yelling directly at you?
Correctly, yes, and he was talking into his phone at the same time.
Okay. And since the early March of this year, was there an incident where he got, you said, right up in your face?
Oh, absolutely. That was, I was actually on a tractor doing some work on the property, and I pulled onto the easement to go down the road. Mrs. Thompson blocked me with her bicycle, and then Mr. Thompson drove up to me on his bicycle and started just cursing me and yelling at me significantly. Again, I've got video of all of that. That was one. And then about the 10th of July, might have been August, I can't remember now, one of the two, the Thompsons had placed signs on my entrance into the property. And so I was removing those when Mr. Thompson came out and accosted me again verbally for a protracted piece of time. And then he left, and then he came back and did it a second time.
Okay. So since that arraignment, that conditional release agreement back in March of this year, and that would be March 3rd, so since March 3rd, 2025, estimate for us how many times has Mr. Thompson kind of directly, verbally contacted you?
8 to 10 times.
8 to 10 times. Okay. No further questions, sir.
Questions, sir?
So, Mr. Reed, at this gate that where a lot of this activity takes place, you have at least 2 surveillance cameras that surveil the area all the time, correct?
I do, correct.
Where's the video from those cameras that might back up some of these things that you're saying?
I have them available
Well, why aren't you producing it for this?
because I wasn't asked for it
By who?
by the district attorney's office.
So, does he know you have this video?
Yes,
And yet, he didn't ask you to provide this video.
no, didn't need it, supposedly.
Why wouldn't you need to?
Objection, speculation.
So, there are other video surveillance cameras surveilling my and my wife's easement, an area where we have an expectation of privacy, the whole length of it. Correct? There have been as many as 6 surveillance cameras on our
Sir,
easement.
if you're going to ask questions, give him a chance to answer.
Okay.
This is not a time for you to make speeches.
Okay. I'm trying to ask him.
Wait.
I asked him how many.
Sir, be quiet. Ask a question, give him a chance to respond. Don't make a speech.
There are, how many cameras have you had focused on our easement?
Effectively, I have 3.
How many have you had at various times?
Well, I've moved them around while I'm trying to determine what's the best place to have security around my home.
So the sole purpose of these cameras is for security at your home?
It's security and also to maintain, because I've had issues with you and your wife doing things at my gate.
Like what are you talking about there? Could you explain that?
Absolutely. I have video of you taking those gates down and removing them from my property. I have video of you using logging cables to block me off from being able to get to my own property. I have multiple things.
Tell me about these cables. Did you cut a big lock and a cable off of one of the sides of our easement?
After warning you that if you didn't remove them, I was going to.
What did that cable do that you cut off?
Objection, relevance?
What is the relevance of that?
Well, the relevance is why he has all this surveillance and video that violates our privacy and our constitutional rights to privacy and secrecy and the enjoyment of our property. So let me word this a little differently. this cable that you cut off, that accesses an entirely separate piece of property from our easement. Is that correct?
There were 3 cables. One went across.
Would you please just answer the question?
He's describing 3 cables, and you have described one. And
That's
so-
the one I'm asking for.
Let him answer the question.
There are 3 cables that you installed. One was across the easement. One blocked me from the rest of my 26 acres. And the third one goes into a piece of property that my folks own.
So this other piece of property where you cut the lot, 1 cable, 1 lot cut, that's all there was. What's that property have to do with this easement?
It is my parents' property, and it's where we intend to run cattle.
So what does that have to do with our easement? The easement is property specific. The easement is an in-rem jurisdiction. It's not a personal jurisdiction. It goes with the land. Here's a litmus test for you. Let's see if you can understand this. So, do you think...
You're making a speech, sir. Ask a question.
Okay,
Ask a
okay.
question.
If we sold our property, what rights would the new owners have to that easement that the deed includes?
Have the ability to
Just hold on.
come.
Objection. I'm not sure what the relevance or the personal knowledge of this witness would be.
So,
Sir, have a seat.
pardon?
Have a seat.
Too quick for me, Your Honor, sorry.
You have another question?
Okay. Looking at this conditional release agreement,
Have a seat.
okay,
Ask a question.
okay, Mr. Reed, have you examined this conditional release agreement?
I've looked at it, yes.
What in this conditional release agreement tells you that you can use the easement? No, excuse me, my wife and I's easement. It's not your easement, you understand that, right?
I do not.
What in this conditional release agreement indicates that you can use the agreement?
I'm sorry, I don't understand the question.
Is there anything in this conditional release agreement that tells you that you can use the easement? Because there's a contact issue here, obviously.
Let him answer the question, and you, rather than you give some other explanation.
The conditional release agreement has nothing to do with the easement.
Okay, let's, I have a question about,
Have a seat, sir.
pardon?
Have a seat.
Oh, you want me to ask sitting down? Is that what you're saying?
If you don't have to stand up and ask
okay.
a question. If you're going to address the court, you have to stand up.
Thank you. Okay, there is, I'm looking for this thing here. Have you looked at the minute order that was issued at the same time as the conditional release agreement?
I have not.
I know I've got the thing here somewhere, but, minute order. Okay. I have here a minute order, and this is the order that the court makes when they do these things. No in-person, electronic, or third-party contact, I'm reading this.
Objection. Is there a question here?
Yeah, there is a question.
Mr. Reed has testified he hasn't even looked at this order, so.
Oh, what's the question?
Well, the question is that it's hard to, I agree with Mr. Fleming here that it's hard to ask him a question when he hasn't seen it. My question is, though, I mean, maybe I should just present this in direct evidence. Would that make more sense?
I don't know what makes sense. I'm not sure what a minute order would help you or hinder you in your response.
Do you have the minute order there, Your Honor?
I don't know what date you're talking about.
The date of this minute order is the same day, the date
What's the date?
of the conditional release.
What's the date?
What was that thing? Dated here, it looks like March 3rd, 2025.
So what are you intending to rely on that for?
Well, the minute order, as far as I can tell, is just an explanation given by the court to help understand what it was doing. And there are a number of things in this minute order that transfer to this very defective conditional release agreement. One is these people's names. There's only one person who resides on the property where our easement is located. And yet we have people from all over, the people who live who knows where. One guy lives in Eugene, Oregon. And it also lists an address of 509.
So what does that have to do with the allegations here that you violate the terms of the release agreement?
The court's asking me.
Yes.
Right? Okay. What it has to do is this. It says an address of 50900 Maston Road. That's not the address. Our address is 50910 Maston Road. That's the address that belongs to our easement. It lists people who aren't even around. It lists.
So whose address is 50900?
That's Mr. Reed's address.
Okay.
Our address is 50910, and that is the address that easement belongs to.
Okay. What does that have to do with the allegations that you had contact with this individual that is clearly denominated there in the release agreement?
It says here, and I don't think it's that clear at all. Obviously, I don't understand what this. Often conditional release agreements with non-contact orders have some kind of a condition for space or something. You get so many feet of something. I'm on there. I'm being stalked and hunted day in, day out on my own easement, coming and going. And so is my wife, by the way. But back to this minute order, it says defendant may still use the easement for coming and going from his from residences. Say what residence? I would assume mine, but it's my easement. Could a conditional release agreement bar me from it?
I don't know how I can make it more clearly. The allegations are not that you were using the easement unlawfully, that is, you were going to and from your property, but that in the process of going to and from your easement, that you communicated, that is, orally spoke at a victim, named victim. That should be clear.
Well, but it isn't made real clear. But in the context, but I am the one being contacted, not the other way. So so I can be on my property, my easement, and have someone come and confront me at close range, at high speeds, and I just have to put up with that when they don't even belong there in the first place? See, so this is where perhaps this, I believe I even filed a motion to modify this conditional release agreement way back when.
Okay.
Because it makes no sense.
Your objection, okay, I have duly noted the minute order. Next question.
So,
Next question.
yeah, I'm just going over some thoughts here. So let's look at this conditional release again. The oral record of the hearing.
Okay. This is not a time for you to make an argument to me about what this means or violate the terms or whatever. Questions of him. You have a question of him.
Let's see, I'm trying to decide who I'm even asking questions to here. No, I have no more questions.
Right. Any further questions?
No redirect, Your Honor.
You can step on down. We're going to take a brief recess. Do you have any further witnesses?
No witnesses, no exhibits. I just asked the court to take judicial notice of the conditional release, which I believe Your Honor has, and nothing further.
Okay, we're going to take a brief recess. Have a seat, folks. So, you're done, you're not intending to call additional witnesses, is that right?
No, Your Honor, no witnesses.
So it's your time to present evidence, sir. You intend to call witnesses?
I will provide some testimony first, and then I will call my wife as a witness.
So if you're going to testify, step up and be sworn.
Okay.
Stop and raise your right hand and be sworn.
Do solemnly swear the testimony you shall give in this now pending matter be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Please state your name, your first and last name, and spell your last name for the record.
Ronald Ray Thompson, T.H.
And you are the defendant in this case?
I am the defendant.
Are you the defendant?
Well, that's somewhat questionable because I actually am the victim.
Sir, are you the defendant in this case?
I'm named as a defendant.
You are the victim in this case.
I believe so.
Okay. What would you like me to know?
I guess first off, that the bulk of Mr. Reed's statements were patently false.
Okay, sir, you're not to comment about the truth and veracity of another testimony. You're here to testify, not to say somebody else was a liar.
Okay, I will, thank you. I'll try and, try and keep that in mind. The first thing, and of course this came more from Mr. Fleming, is that there is no shared driveway. That there is no document or anything to suggest that there is a shared driveway. There has never been a shared driveway. This easement was created by deed on October 5th, well, before that, but recorded on October 5th of 1971 between my aunt and uncle and my parents, and it has remained in effect that entire time. It is the only property that has this easement, that is the easement holder. The other property that was held by my aunt and uncle for until after my grandfather died. My grandfather lived on this property. After he passed away some years, this property didn't have a deed until 1988. At that point, the property was sold to Robert and Donna Reed, Kim Reed's parents, and it was sold subject to an easement and a number of other things, some that we've already been across. But that clearly reinforces the 1971 October 5th deed, and it does not, it's recorded with the book and page number in the county records. There is no other property that is subject to that easement on that 88 deed.
Well, when you say subject to,
The 19
subject to property is.
The Servian-
Sir, the subject to property that is the property on which the easement lies.
Yes, that property is subject to our easement.
And when you say there's no other property that it's subject to, I think what you're trying to say is nobody else, no other piece of property can access that other than you and the underlying property.
That's not right. I didn't say that. What that means is oftentimes there are multiple easement holders. It's Oregon law. When there are multiple easement holders, one of the things, it has to be noted, and it all boils down to the original contemplation of when that easement was created, and that was in 1971. There were no Reed family members that had anything to do with that. When there are multiple easement holders, there also must be a maintenance agreement between those easement holders. We have an easement that requires maintenance, trees go across it. We might have 5.5 feet of snow on that easement. Who maintains that? Who plows it off? I do. I'm the only person who has ever maintained that easement and plowed the snow off of it. Nobody else has to this day. So where's the agreement for that when they have multiple holders? It has to be some kind of agreement. And talking about a shared driveway, you can't just automatically call something shared. There has to be some kind of understanding of sharing that is in place. You can't just come along and say, "Oh, I'm going to share your driveway now." That just can't happen. So for those reasons, it says that driveway or the easement, and it's not a driveway. It's an easement for quote roadway purposes. That includes every purpose conceivable for that roadway, and it's for the benefit of the dominant tenement, not the servient. The servient property has a duty and an obligation to not interfere with that easement in any way, shape, or form, which includes driving on it. Just because somebody else has a long established road and easement, those things are all determined at their inception. They can't have somebody coming along 50 years after the fact.
So you're making a legal argument now.
Yeah, that's kind of a legal matter. So to kind of bend it back around to this conditional agreement, I'm being interfered with on my easement.
That's a legal argument.
No, that's a fact. I know when I'm being interfered with and being confronted constantly is interference. It's the ultimate interference is what it is. So here I'm placed in a position of with this conditional research. By the way, the whole creation of this, I've been through a number of these things. I come and observe a lot, and I see how conditional release agreements come about. And it's usually through some kind of back and forth discussion and negotiation between defendants and the council and the court to get a clear understanding. That never happened here. That I was not ever consulted into the wording of this. It was just wham, bam, have some clerk come over and stick this thing in front of me and say, your liberty's gone if you don't sign this. I've never seen that happen with any of the defendants, even today. There's some understanding to get some clarity on exactly what is taking place here. Now, on July 6th, after all of this is taking place, and we're constantly being interfered with.
So, sir, if you just state facts, not...
Okay, facts. Yep.
Sir, you're wanting to add little things here and there, side comments. Forget the side comments, please.
Okay. So as an example of another conditional release agreement, Mr. Robert Kim Reed, here's brother, Timothy Craig Reed, was visiting, and he actually came out and accosted me at the gate when I was trying to leave of the easement, and I had to leave, and so I just kind of ignored him and left after a few words. But he hung around out there, and this is on July 6th of 2025. He ends up assaulting my wife when she comes out to the gate.
So-
Physical assault, he's been charged.
Sir, is that allegation here?
Well, I have a copy of his conditional release agreement here, and the point of this is
Your Honor,
that Walter,
if I may object to the relevance, that's part of a separate matter. That's just not part
there
of
is
what we're dealing
nothing
with.
separate
We're dealing
about
with today,
this.
it's not an allegation.
Okay,
It's-
there isn't that allegation here. Let's stick to what the allegation is here.
The allegation here is with respect to a conditional release agreement, correct?
It is with in relationship to this violation of the release agreement.
Okay, so the point is that there was nothing clearly explained licensing Mr. Reed and his other family members to abuse the situation by creating unwanted conflict and contact on a nonstop, all day in, day out basis. So the rules behind this conditional release agreement were not clear.
So, sir, are you alleging that the incident that was depicted in the videos did or did not occur? Is
Which
that a yes
incident?
or a no?
Which incident?
The two incidents that were depicted in the video.
I would say they occurred, but they are not accurately depicted. And there are countless examples of us being stalked and harassed and chased down on our easement to try and create a situation like this. Mr. Reed made a comment about, a couple days ago he came out there. What he said was totally false. I was riding out on my bike to go for a bike ride. I got out to the gate, and he came tearing across the field unnecessarily on his ATV and drove right up to me 10 feet away. And I didn't say a thing. He was baiting me to try and get me to say something to him. I don't say anything to him. He says all kinds of things. He says all kinds of things directly to the surveillance camera that we have at our gate. He sticks his face in it and makes insults and everything on a daily basis. That, I believe, is contact, and that's unwanted. So we don't have a shared situation at all. That has never been sought. This was never anybody else's driveway for over 50 years until Robert Kim Reed came along. And there was no discussion. We were never approached to say, hey, what do you think about sharing this easement? Can we make some kind of arrangement here or something? Which would typically happen in a sharing situation. In fact, you might even want to write it down and call it a contract. There was never anything of that. It was like it was coming in by military force and taking over. And the whole idea of an easement is that you're not interfered with in coming and going to your property. Not only that, you get the full enjoyment of your property through that easement. And it's a deeded easement. This is something that came along.
So I'm going to object here, and I'm going to, though strangely, I'm going to say asked and answered because it seems to be
Numerous
repetition.
times.
So since this word easement gets kicked around quite a bit, I haven't seen any evidence that anyone in this courthouse even has any idea what that word means. And you probably do.
So I'll object again because I
I
don't know what the relevance of this
I'm going to
is.
tell you what the word easement means,
Well,
specifically.
Sir, if you have legal definition of easement, you can cite me to case law. I don't need you mouthing what you believe an easement means.
That's not what I was trying to do. I was just trying to
Well,
explain
you were insulting myself, other judges, and other scholars in the courthouse here about what easement means or doesn't mean.
Well, I'm a scholar myself, Your Honor. I'm 77 years old. I've dealt with easements my entire adult life at over 50 years. And
What about the facts of the case here that you want to testify to?
well, the facts are questionable. I don't buy the facts, and they certainly aren't any kind of anything that could be used to revoke a conditional release. You already have people here like Mr. Fleming and Mr. Reed here. They've already done everything they can to interfere with our property and the enjoyment of it to the degree that they want to seize control of it and own it. And they aren't able to do that in the civil justice system. And so now we're working a criminal angle here, and they aren't.
So I'm going to object to
with that.
this.
I'm not done talking.
Your Honor.
What they're trying to do is use the criminal justice system to interfere with my liberty and take me off of my property wrongly.
Anything else factually you want to say?
I think you understand where I am. I don't believe that I have done anything that would warrant the revocation of a conditional release. If anything, it should be clarified, as I filed a motion to do long ago.
Do you have any cross-examination?
Very briefly, Your Honor. So, Mr. Thompson.
I object to this condescending behavior, which I say, well, you can tell when somebody don't have the facts and the law on their side, they resort to ad hominem attacks on people and lies.
He said he was asking liberty to ask you a couple of questions. And he has.
But it was the way he said it.
I didn't take that he was being insulted.
Well, I did. Okay.
Okay, Mr. Thompson, so you testified a little bit about the conditional release agreement. So you were present at the arraignment on March 3rd, 2025 in person, correct?
Correct.
Okay. And you did sign the conditional release agreement, correct?
Under coercion.
No.
You signed it, correct?
I signed it, yes, but under protest.
Okay.
And I immediately objected by filing documents.
And you were there in person. You heard when the Honorable Judge Harriet announced the conditions of your release from the bench, correct?
Yes, I did, and I have the minute order, and the conditional release agreement does not concur with the oral record in that court.
I appreciate that, sir. No further questions, Your Honor.
You can step on down. You intend to call additional witnesses, sir?
Yes, I do. I intend to call my wife, Rachel
Okay.
Thompson.
Ma'am, if you'd step up.
Please raise your right hand. You do solemnly swear the testimony you shall give in this now pending matter be the truth, the whole truth, and nothing but the truth?
I do.
Please state your first and last name and spell your last name for the record.
Rachel Thompson, Thompson.
First question.
First question. Were you
First of all, why don't you identify yourself and your relationship to either party here?
okay?
Me?
Yes.
I'm Rachel Thompson. I am Ron Thompson's wife.
Okay. Go ahead, sir.
Okay, so you, along with your husband, own property with the current address of 50910 Maston Road, correct?
Yes,
And how long have you owned that property?
About 9 years?
So when you became an owner of the property and decided to live there, you recorded the deed with your name on it, correct?
Yes,
And that deed included the description of the property together with, the wording, an easement 30 feet in width along the eastern edge of another property to access that property.
yes,
There was no other party that ever used that road for any purpose, is that correct?
yes,
And so it had a certain character and everything that was liked, and you lived there and helped with the maintenance, clearing of some brush when it was necessary along that easement, correct?
yes.
Did any other party besides you and your husband ever do anything with respect to that easement?
No,
So were you clear in your understanding when you became an owner of the property that you were the only holder of that easement?
yes,
And did you ever examine the servient property deed and to take note of the fact that your property was the only holder of an easement?
yes,
And the page and number of that original deed from 1971 are noted on that 1988 deed to that property,
yes,
and no other property.
yes.
Do you currently have a quiet title lawsuit filed to address this matter and get to the bottom of it once and for all?
Yes.
And what's the status of that quiet title lawsuit?
It is stalled at this point because of Judge Harriet's recusal in all matters.
So Judge Harriet, that's the same Judge Harriet who issued this conditional release order?
Yes,
And that judge is now recused herself?
yes.
And how did you find out that Judge Harriet had recused herself from our matters?
Through a letter by her attorney, somebody with the last name Garza.
Yeah. So at any rate, she has presided over all these things, but has now recused. Is that correct?
Yes,
So
over
okay.
9 cases that are
So-
still active.
You were also present in the courtroom when Judge Harriet, who is now recused, held this arraignment and issued this conditional release agreement that was brought over to me to be signed.
Yes,
And did Judge Harriet make it very clear what all this no contact meant?
no,
So you were also present for an arraignment of Timothy Craig Reed, Kim Reed's brother, correct?
yes,
And Judge Miller presided over that.
yes,
And do you feel that Judge Miller made it very clear what the conditional release agreement involved?
yes.
And what did he do that made that clear?
He told Timothy Reed to stay off the Thompson's easement.
And anything else? Did he name any individuals or anything to not have contact with?
Myself and you,
And
Ron
that's all-
Thompson.
And that's all in the conditional release agreement?
Yes.
Does that release agreement concur with the oral record in the court?
Yes,
So, so back to, you saw the videos here, correct?
yes,
Have you seen a lot of videos of that kind of thing?
oh, yes,
And you heard Kim Reed talk about a time he was on his tractor and you were on your bike or something and described this thing. Was his description of that incident accurate?
no.
So what happened in that incident?
I was riding my bike down my easement going toward our house. Kim Reed was in a tractor on his property, and as I was riding down toward my house, He came off of the easement, came off of his property onto our easement for absolutely no reason but to stop and turn off his tractor right in front of me. He was not on the easement.
And where did that leave me in relation to this conditional release agreement?
Where did that leave you? I don't understand.
Mr. Reed stated that I came along on my bike or something and had words with him. Is that true?
No.
But I did come along.
You did come out, yes.
Yeah, and I was driving, was I driving a car?
No, you were on your bike. You were, I think, yeah.
This happens daily. Okay, but I didn't confront him or anything. He was already there confronting you.
Absolutely, and you are constantly, we have to protect each other while we come and go every single day.
So you saw the videos there?
Yes.
And Mr. Reed stated that I was in a car. He actually states in writing here that I drove past. Did you see me drive past in that video? Was I driving past him? Maybe we should look at that again. Can we look at that again?
We're parked, and he came up to you. That's what I saw. I don't think you were driving. You were, I don't know, remember.
He also stated in his testimony that you were in that car. Were you in that car?
I don't believe so.
So,
Again,
he's
it's
giving
everything.
inaccurate information there. Would you say that's true?
Yes. We have our own hundreds and hundreds and hundreds of video.
Yeah. So, who resides in Mr. Reed's house at 50900 Maston Road, which is incorrectly given an address of our easement? Who else resides there?
Just Kim Reed.
And his parents, Robert and Donna Reed, where did they live?
About a half a mile away on the other side of the river.
And they were the previous owners of that property up until 2020?
Yes.
Correct. Did they ever use that easement for anything, let alone a driveway?
Not once.
So, let's see. So the other named parties in this conditional release agreement, I believe we have Robert and Donna Reed. I don't understand why they would be involved in something like this. They don't even live there. They're former owners of a property. And do you understand what contacting them would be?
No, I don't.
Would it seem to you that to contact somebody, you would be going to them and approaching them?
Absolutely.
And not the other way around?
Right.
And have I or have you ever done that, to your knowledge? Gone to seek out contact with them?
No.
So, that is a kind of a big issue with contact. In my
Okay, so sir, ask
yeah.
questions. You're not to make your
I just have to
editorial comments.
I don't have a list here. I'm just thinking out loud a little bit. I'm sorry. So then we have so Karen Reed does not live there,
No.
and we don't really know where. Do you know where she lives?
No.
And then we have a Casey Reed listed on the thing. It's spelled two different ways. Does he live anywhere around there?
No.
Do you know where he lives?
I believe in Eugene, Oregon.
Yeah, and so to contact him, you would have
Okay,
to go
so
there.
sir, next question.
Would you say that there has been a fairly extensive amount of litigation involved to get to the bottom of this easement issue?
Would I say that? Yes. Oh, yes. Since
And
13 years.
And does it look like it's anywhere near any kind of a resolution?
No.
Would you view these charges, these underlying charges, and this conditional release business as an effort to interfere with your easement and your property rights?
Yes.
Objection.
She answered the question.
Somewhat spurious insults to both the DA's office and the victim here.
Sustained.
Do you, okay, are you aware that the DA's office, through Deputy District Attorney Kyle Fleming, has already been involved with another supposed crime that took place a few years ago?
Yes.
And so we had basically the same little...
Sir, if you'd keep the editorial comments to a minimum.
Okay, I thought I just had a question.
Wanting
Okay.
to add
So-
spurious kinds of things.
So in this previous case, were you very aware of how that all worked out?
Objection relevance.
Sustained.
So at that previous time, was I found to be guilty of trespass?
Yes.
So from your personal knowledge, did I trespass?
Objection. Come on. If you're found guilty, you're found guilty.
Oh, no, Your Honor. People are found guilty all the time who are innocent.
So if you were found guilty, and now you dispute that, apparently that went to a fact finder, and so that's the facts in that case.
No, there was no factual evidence presented. There was no evidence at all that showed anything at all.
It went to a jury trial? Is that what you're saying?
It did.
Yes.
So you want to impeach the verdict, and that could be done by numerous ways. That has been determined.
Well, the fact is we have a first-hand fact witness here who knows that trespass didn't take place.
Okay. Apparently she had the right, maybe even the obligation to testify at that, and was found perhaps not to be truthful. It's found that you were guilty of a trespass. So move on. Next question.
So, this is what we got here. Okay, conditional release. So do you, from your experience, ever since this conditional release came about, has it ever appeared that you and specifically your husband were targeted and stalked and harassed on your easement, going to your home?
Yes.
Is it possible for Robert Kim Reed to come and go to his house using an old existing road instead of the easement?
Yes, and Timothy Reed did use that road.
After the conditional release?
Yes.
Yeah.
He had to.
So any time that I am on our easement, our deeded easement that we own, we're the exclusive holders of, anytime we're on it, we're subject to being stalked and run down on ATVs and side-by-sides and tractors and everything for the purpose of confrontation.
Yes.
And do you think that when you or I are out there and we are being confronted by something, that a conditional release agreement states that we are contacting them if we say anything, when they're there totally to provoke that to be done?
That release agreement, in my view, is impossible.
And how is it impossible?
Because we've been using it forever, and now all of a sudden we have to watch out for people who don't have a right to it. It's not a shared anything. Just because they built their house 30 feet, their front door is 30 feet from our easement. That's not my problem.
So do you feel that your constitutional right to be secure in your property is impacted by this?
Absolutely. Every day, and every night, and all day long. I sell duck eggs, and I am confronted by him at the end of my own easement when I am doing business with friends.
So from your experience on January 1st of this year, was Robert Kim Reed there on your easement confronting and harassing you and other people on New Year's Day?
Yes.
So you are not aware of anything that could be suggested to be a shared driveway or shared easement?
Absolutely not. I've never even met these people.
What's your understanding of roadway purposes, which are the purposes for which you own this easement?
Okay, I'm just going to object. I think we've heard a lot about kind of their understanding and their belief on what this easement is, and I'm just going to say it's redundant at this point.
So do you feel that you're able to enjoy your property rights
Objection
since
asked and answered.
since this? So how you live in this area? It's somewhat remote at the end of the easement. How would it impact you? What do you see happening if this conditional release is revoked?
Objection relevance to whether he violated it, how it would affect her if it was revoked. It doesn't seem to be relevant.
Do you feel that that this effort to revoke this release would place you in a very dangerous position?
Yes.
Objection relevance again.
Your safety and security, do you think your safety and security would be highly at risk?
Same objection.
Do you view this entire incident or any of these things as interference with your easement?
Objection asked and answered.
Okay, let's see here. So back to this video evidence business. How much video evidence have you seen ever since Robert Kim Reed came here
Objection asked and answered.
that have you seen evidence from surveillance cameras that show Mr. Reed improperly making contact with anybody on our easement?
Yes.
Have you seen him confronting other people other than ourselves on our
Objection
easement?
relevance.
Yes.
So, do you feel that from what you've seen from this video here, there's only two. They say that there are many. We have hundreds. Would you say, from what you've seen there, that would violate what you understand the conditional release agreement to be?
No.
So, did the conditional release agreement stipulate any kind of distance to stay apart from people?
No.
Objection. I think the court can read the agreement for itself.
Have you seen conditionally release agreements or no contact orders that stipulate a certain number of feet of separation between people that would prevent anything like that?
Objection.
Okay, Your Honor, I have no more questions. I believe that I have appeared and showed cause why it should not be revoked. It maybe should be defined a little more clearly to...
You can have a seat, sir. So, any cross-examination?
Just a couple questions, Your Honor. Thank you. So, Ms. Thompson, you mentioned before that the two of you, quote, protect each other on the easement. Is that right?
Yes.
Okay. So, Mr. Thompson coming to protect you would be him coming out to confront people he thinks you need protection from. Is that correct?
No, he's
No?
watching.
He just stands there and watch.
Yes, or drives his car out when I come home.
So he drives his car out and then he stands, what, within a few feet of Mr. Reed, is that right?
Doesn't stand, he stays in his car and waits for me to come home so I'm not confronted by any of the Reed family.
Okay. No further questions here.
And that's all your witnesses, Mr. Thompson?
I believe so. I mean, obviously, you could see we could watch easement videos for weeks nonstop. But
So we're going to stand in recess. And when do I have tomorrow on the docket, Claire? Excuse me? We have a 3 o'clock what? So 11 o'clock, and there've been several comments about case law defining easements and the right to restrict and right to exclusive use of easement. If you have case law to that effect, I want it in my office tomorrow by 8:30 in the morning. Both of you. And what those definitions mean.
where's your office?
It was, excuse me?
Where's your office?
Well, you can get it to the clerk's office
Okay.
and with this case number on it, please. They'll get it to me. And that is case number, case citations, page and number, volume and page. All right, thank you.
Thank you.
Thank you for coming to Deschutes County, Runner.